last time we said that we can vaguely or largely categorize the stages into pre-action, intra-action, and post-action. So we're going to put a little time only on pre-action. Okay, what are some of the things we have to consider before we start, and why? Okay, we talk about the costliness, how expensive litigation is, how we don't know whether it's worthwhile suing the defendant. So before we start, well, we want to check the costs involved. You never know, or you can never estimate too accurately, right? Because you don't know how long your litigation is going to last. You don't know how many applications you're going to have to make or the other party is going to make. So you can only estimate and prepare as best as you can. So I guess you can look at this kind of considerations from the viewpoint of you being a prospective lawyer, okay, a potentially that's progressing as a potential lawyer, or even from the eyes as a litigant. So, not quite right. Okay. So if you are working for the firm, the solicitor's firm, whether you are a legal executive, you are a solicitor, we've just started, okay? Okay, so if you are acting for the, if you are an employee of the firm, whether as a solicitor, a managing partner, a legal executive, or the like, before you actually take on the client, you actually have to do a self-evaluation. Is your firm, or if you're the solicitor, are you capable and competent to handle the case? Remember of all the things we talked about in Hong Kong legal system about conflict checks, about competence, capability of the firm? All those apply, right? So is your firm capable, let's say it's a personal injury claim from a traffic accident, and the victim, the claimant or the plaintiff, okay, let's keep on using the word plaintiff. So the plaintiff comes around to your firm and tells you about all the details of his case or intending claim. Does your firm do PI cases? Is your firm too busy? Okay, sufficient experience? Any potential conflict of interest, okay, between the firm and the solicitor, between the firms / solicitor and the client. Okay, some of those examples you might have heard previously include, okay, firm and solicitor. So let's say it's a financial claim, okay, so forget about the PI claim. So let's say it's, let's say your firm is approached by HSBC. So HSBC approached your firm and tells you, yes, I would like to, I have a litigation ongoing with against Bank of China. Okay, it's a big case. HSBC against Bank of China, right? So before you start asking all the details, a potential conflict of interest, what can it be? What if your managing partner is a very large shareholder in HSBC? Would there be any conflict of interest? It doesn't have to. Okay, you can be a shareholder and you're not involved in the management, that's fine. Okay, you may only have to declare your managing partner's interest. What about between different clients? What if HSBC approach you and actually you have been working or you've been acting for Bank of China? So Bank of China is already your existing client. Now, it doesn't have to stop you there. Well, perhaps you're only acting for BOC, Bank of China, on totally different matters. Perhaps only on commercial leases, right? That has nothing to do with this litigation with HSBC. So you can still act for HSBC, right? If you check, there's no conflict of interest, that's fine. You also have to check whether any other legal firm is acting for the same client. Is anyone else working on the litigation for HSBC, for this litigation, this intended litigation? Okay, if another firm is working or acting on behalf of HSBC for this case, then you have two options. Okay, if you want to act for HSBC, either the client terminate its retainer, so HSBC has to terminate its previous retainer with another firm, or that firm agrees anyway. Okay, so then you can still act for HSBC. Okay, that goes without saying. Remember, as I told you, the first 3 topics in your course manual is very much common sense. So you say, what am I learning about law here? This is not law, right? This is common sense. Then you take proper instructions, you identify the real client, and you take a proof of evidence. Okay, identify the real client. Why is that? Okay, it's very, very often we have a client, like let's say if you have a traffic accident, Peter, can I check there's no Peter here? Because I'm going to keep on using Peter. Do we have a Peter here? No? Okay. So Peter the plaintiff has been the victim in a traffic accident. His wife is now seeking your advice on how to claim. Now let's say Peter is very fortunately, Peter's been involved in the traffic accident, but not, well, he suffered injuries, yes, but he still has full mental capacity. So we're not talking about a situation where the wife is acting on behalf of the husband, okay? So Peter, luckily, still maintains full mental capacity, so he can act on his own behalf. So the wife keeps on coming to you and say, yes, I think we should claim that stupid driver and his company, and etc., etc. So she's been the one that has come up to your firm 3 times, even before asking about whether to start the action, how, costs involved, etc. Okay, you want to have a conference with who? Who would you want to have the Peter or the wife? Peter, because he's the real client, right? But perhaps Peter's wife, Winnie, okay, W for Winnie. Okay, wife for Winnie, or Winnie for wife. Okay, so Winnie keeps on telling you, no, it's fine. I know all the details of the accident. I was in the car at that time. I was a passenger, or I saw it happen. So it's okay. Just ask me all the stuff. I can tell you. Peter's not very good with communication. Okay, he stumbles and he doesn't get things clearly out to you. But as a solicitor or legal executive or whatever, you have to have a conference with Peter, right, rather than Winnie. But in real life, it happens a lot. It happens a lot. And there will be people actually blocking you sometimes, right? So standing in the middle say, no, that's fine. But okay, so identify the real client. Take a proof of evidence. Now, you sometimes hear that word in both civil litigation and criminal litigation. Proof of evidence is just written instructions based on what the client tells you. Now, sometimes you may even have the client preparing one for you. If he or she very organized, he actually had kept a logbook about what actually happened through the timeline. That's great. Most instances, you will be the one taking down, perhaps during conference or teleconference or Zoom meeting, whatever, what the client told you as what happened. So you type it out and you confirm with the client and have him signed and dated. Right? So, of course, sometimes you would say, in actual practice nowadays, if the client is very conversant and fluent with English, fine, you may take your notes in English. If not, you may take it in Chinese, depending on the language, because what the main thing is that you want to make sure that's the client's instructions. There's no point writing Shakespearean English after the conference in Kunti or Chinese and let it see, this is your, this was what you have told me, come on, date and sign it. Okay, if he or she doesn't understand. Okay, so why do you think we want written instructions or we want confirmed proof of evidence? Why do you think so? Just like in criminal cases, what if the client, well, to give benefit of the doubt, perhaps forget what he told you, or changed his mind, which is dangerous for the firm, right? Because he turned his back, and if the case didn't go well, he may turn around and say, no, that's not what I told the firm to do. Okay, they ignore my instructions. So you want to protect the firm as well. Right? And I guess the very first and foremost purpose is to clarify the instructions. That should be your first and foremost purpose of the proof of evidence. But otherwise, it's a good record for everyone. Identify the potential causes of action. In most civil cases, okay, forget about your exam mock questions. In real life, in any typical civil litigation, you have multiple causes of action. Okay, it's a matter of whether you can identify it. Of course, when we study law, we try to simplify the scenario, given that you're studying the subjects one at a time, right? So perhaps we'll only give you, yes, it's a contractual breach, or if it's a traffic accident, it's a personal injuries claim under tort of negligence. But in real life, there'll be more than one in a typical case. So you understand the causes of action now, since you've done your obligations, business associations. So in a, let's say an employee stole money from the employer, one way or another, okay? Can you tell me, can you suggest to me what can be causes of action? Okay, it's like, let's say, in a more sophisticated way. So the employee meddled with the accounting records and somehow did some transfer of money, forged some documents, and in the process, misappropriate some money. So what can you think are the potential causes of action? Okay, as I told you, there'll be more than one. So can you suggest to me something? I mean, yes, you haven't done criminal law, but let's say on the civil side, what do you think can be? Okay, whether it's criminal, civil, what comes up to your mind? Yes, that would be a breach of employment contract. What else? Fraud, yes. Because you can also, fraud doesn't only, it's not only in criminal. Okay, you can have fraud and what we call tort of deceit. That's what we label fraud as, okay, in the civil sense. Okay, you hear fraud and forgery in criminal cases a lot, right? But we can also which can also be causes of action in civil, okay, in civil litigation. So fraud, breach of employment contract, you've done tort, and you haven't done trust yet, right? That's the second year, right? So also breach of what we call employment, apart from employment contract, as an employee working for an employer, what other duties do you think there is? I think you've heard of the term, but not very not many times yet. Breach of fiduciary duties. Yes. So all those, right? And you can probably also, the damages probably comes from the breach of employment contract and the breach of fiduciary duties. Okay, so at any time there can be more than one. Okay. Merits and strengths of the client's case. And don't forget about the weaknesses. Now, client expectation management is actually an art. Okay? So when you have all these pre-action considerations, if you are acting on behalf of the firm or the solicitor, if you're sort of as an employee or as a managing partner, it doesn't matter. Part of the process, while you analyze the case, take instructions, analyze the case with the client, part of it is actually to assess, should we pursue the action? Is our case strong enough? Do we have some sort of sufficient evidence to support our case? Also, at the same time, you're also managing client expectations as well. Because if the case is only 50-50 chance of winning, or is an uphill battle, or is it a clear-cut, easy-to-win case? All this you also have to, although it's at a very initial stage, you haven't seen all the documents yet, you have to help the client to assess and analyze the case. Okay, we've got this, but so far with what you've told me, yes, it seems we'll have a breach of fiduciary duties and this and that, and the employee was still within the contract of employment contract, so you can sue on this and that and that. But do you have any records of the transfer or the accounting records, or perhaps the employee have also stole the records? Okay, so all this you have to think about as in the causes of action, the merits, and the evidential issue. If you're, on the other hand, acting for the defendant side in another case, do you have any counterclaim? Okay, counterclaim, I think you know now from your contract, right? You can have counterclaim. Are you familiar with that now? Okay, so counterclaim is when the plaintiff is suing. Okay, let me try to. What's your name? Sorry. Alice. Tommy. Okay, Alice and Tommy. Okay, Alice has ordered 1,000 laptops from Tommy. Okay, Tommy, you didn't deliver on time. Okay, so Alice is now angry and wants to sue Tommy. Okay, so while Tommy may actually say, oh no, Alice, it was Alice. Alice either didn't pay me deposit or didn't pay me from last time, something rather. While Alice claims Tommy, that's what we call a claim, right? So Alice would be the plaintiff and Tommy the defendant. So if the defendant, Tommy, has something related to the claim that he wants to pursue against Alice, that's called a counterclaim in the same case. Okay, that's essentially what a counterclaim is. Okay, so where liability is admitted and only quantum is the dispute, you may also have to consider split trial. Now, split trial is more commonly occurring in personal injury cases. So Peter and who's the driver? Okay, let's use Dimitri again. Okay, Peter, the victim, plaintiff, and Dimitri, the driver, the defendant. Okay, so Dimitri was negligent in driving and bumped Peter while Peter was crossing the road. So Peter sued Dimitri, plaintiff sued defendant. Okay. Defendant had no defense. Okay, let's say, yes, it's broad daylight, there's nothing wrong. Peter was following the pedestrian traffic lights, so he did nothing wrong. No contributory negligence, none of those complex issues. So Dimitri doesn't want to fight the case. Dimitri says, okay, I'm going to admit liability. Okay? But Peter, you are making a claim of 3 million against me. I dispute the quantum. Okay, I know you have been injured, you've got a fractured leg, and you've been staying in the hospital for 2 weeks, but I don't think your claim should be 3 million. I disagree, I think it's too much. So, liability is admitted and only quantum in dispute. So what the court is likely to do is, the court is going to, upon Dimitri's admission of liability, enter judgment on the liability issue. So it's like, remember, it's like a two-stage process: liability and then remedies. Right? In personal injuries claims, money is what we're after. So quantum of damages is the issue. So liability admitted, so half of the issue, the two-stage, the first stage is concluded. Okay, so that's what we call a split trial. So judgment can be entered for liability with quantum to be what we call with quantum to be assessed. Okay, so only assessment of Identify the parties to the action. I've already explained that you need to identify the real plaintiff and the real defendants. Now, what if now Tommy is the director, company director, very prestigious company. Okay, Tommy is the director of, what's a nice company? Okay, Tommy Construction, okay, the company. Okay, so Tommy is actually a company director of that company. They want to sue, what's her name? Mary. Mary. Okay, they want to sue Mary for just say breach of contract. Who's the plaintiff? If Tommy Construction engaged in a contract, entered into a contract with Mary, they supplied Mary with 200 iPhones. Okay, I'm not very creative. Okay, so 200 iPhones. Mary didn't pay. Okay, so now, sorry, why did I use Tommy Construction and iPhones? Okay, it doesn't make sense, right? Sorry, I'm very slow in being creative. Okay, just say for some reason, it's ancillary sort of products, okay? So 200 iPhones. So now Mary didn't pay, so Tommy Construction decided to sue. And Tommy comes up to you and say, yes, our company supplied Mary all these phones and she didn't pay. I want to sue her. Who is your plaintiff? Yes. Okay, that's exactly what I want to say. The plaintiff is the company, not the person, not the natural person coming up to you. Okay, so if Mary entered into the contract as a sole proprietor, then yes, it's only on her. Okay, naughty. Okay, so now put up another scenario now. Okay, let's abuse someone else. Okay, what's your name? Doris. Doris. Okay, for some reason Doris you look very, I need a guy because I'm talking about construction. Okay, what's your name? Royce. Okay, sorry, Doris, we'll leave you for another time. So Royce, okay, I don't mean, I wish everyone good luck and this is not anything, okay, I'm just talking about accidents and traffic accidents, okay. So Royce has been working as a construction worker. Okay, let's say Royce has been working as a construction worker. He suffered injury while at work. Okay, fictional, okay? So he wants to sue. And when you suffer accidents in workplace, who can you sue?
Your employer.
Potentially. Well, another thing to keep in mind, okay, let's say you have a construction site. This is the whole site, and then the building is here, and then there's different floors, right? Different floors, etc. units, and this is where the accident occurred. So Royce was here when the accident occurred. Well, employer, perhaps. Well, what if Royce is a casual worker? There's no particular, it's a contractor rather than under an employment contract. So it's casual worker in another way. So who would you sue? Have you done occupiers liability? Yes? Okay, so you should be very knowledgeable. Tell me who you might sue. The occupier, yes. What else? What have you learned have you learned the case Wheaton Larkin? Okay, the test is sufficient degree of control. Is that right? That's what you've been taught. Who's the occupier? Is the party having sufficient degree of control of the place? Now, when you have, let's say the owner, that's a landowner, right? So they may have control of the whole site. There may be a landowner, a main contractor, as in main developer, okay? Main construction, as in main contractor, subcontractor, subcontractor. What we in Chinese call 大判二判三殺, right? It's pretty typical in it. So who do you want to sue? Exactly. So when you identify defendants, it's also important you identify all possible defendants. Why? Money, right? Perhaps because this bit, you have a main developer or landowner owning the whole place, they may have control. There may be another subcontractor having control over this whole site. There may be a smaller subcontractor having particular control of this. You want to sue all of them in the hope of you get some money back, right? Because they may all have some liability. So if the subcontractor is too poor, you can then still pursue the subcontractor or the subcontractor or the main contractor, right? Someone's going to have money. What if Dimitri, in our traffic accident case, what if Dimitri was working at the time? Who else do you sue? The employer. Remember vicarious liability, right? So all this you should keep in mind. Okay? Yes, I know this is all talking about practicalities and common sense, but this is real life. What if the other side, let's say you are the plaintiff or you're acting for the plaintiff, what if the defendant actually resides overseas? How do you sue? So you actually have to consider the cost and time involved in what we call serving out of jurisdiction. When you want to kickstart the action, the civil action with a writ of summons, you actually have to serve it out of jurisdiction and you have to comply with rules. If they live in Canada or UK, it may be easier. There are different ways once you get the directions of the court, but whenever you need to serve out of jurisdiction, you need leave of the court under Order 11, which we're going to look at, right? But currently I have a case, I have a potential case that I have to serve to Taiwan. It's actually a civil legal system, civil law system. So that poses different considerations because their legal services or legal processes have to be served by judicial officers. So those would complicate matters. Okay, or else you have to involve in quite high cost to engage professional service to serve on the defendants locally. Okay. Any issues of capacity? If you have enough minor, whether on your own side, plaintiff, defendant, or whatever, or on the other side, you have to see how. Okay, even if you take it out of context and not be, let's say it's not a family case, but just any. So what if there is a minor involved in the traffic accidents? You need a guardian ad litem. Perhaps the mother will have to act on behalf of the child, and you need leave of the court again. For any mentally also, if any mentally incapacitated person, same deal. What if, unfortunately, the victim is now in a coma or in a vegetative state? If there's a company involved, as in company construction, you will have to see whether the company is involved or incorporated and registered in Hong Kong or overseas. There are various. As you know from your business association, you can have companies that have been incorporated, let's say in BVI, but they have a registered office here, or if they don't, do they have a place of business, so to speak? Okay, it complicates matters because sometimes if you want to find information about those companies, BVI companies or overseas companies, it's difficult, especially with BVI. Okay? Proper authorization. So if Tommy is acting on behalf or taking the conduct, what we say, taking the conduct and be responsible for giving instructions on behalf of the company, we need board minutes or board resolutions. We need, apart from the board resolutions, you also need letter of authorization following from the board resolutions. Okay, so be careful that you need the proper authority. Otherwise, you're not engaged by the company yet. Okay, I mentioned vicarious liability. So if someone is involved in the capacity or in the event while in the course of business, or employment, sorry, while in the course of employment. Identify the potential remedies. What does your client want in the end? Okay, forget about the emotional vibes and negativities and all that sort of stuff. Make sure you understand what your client is after at the end of the day. Is it just money? Okay, we explained about damages and liquidated and unliquidated. Right? Remember, the difference is that liquidated, it can be ascertained. It doesn't have to be a fixed sum, so long as there is a specific and certain mechanism to calculate it. Rescission. Rescission for contract, you know that it is meaning you want to cancel the contract, right? And quick revision. Do you remember the differences between damages, contractual damages, and tortious damages? Okay, so for your study, be sure you understand that. Anyone can volunteer? Yes, that's a way to directly contrast the two. But if I have to say the aim, where does it help? Where does it aim to put the plaintiff's position when you say backward or forward? Okay, how do you describe it? Any volunteers? That's sort of along the right direction. Any volunteers? You need to know that for your exams, okay? Now, think about tort and think about contract. It's all common sense. If you have a contract, how do the parties relate to each other? By willingly entering into a contract, right? They enter or engage into a legal relationship with each other voluntarily. And they expect the terms to be performed. So contractual damages, sorry, I'm just sidetracking, but contractual damages aim to put the parties in, or the plaintiff in a position as if the contractual terms have been carried out and performed. Okay? Then even if you get confused forward, backwards, okay? It aims to put the innocent party in a position as if the contract has been performed according to the terms. Tortious damage, do they know each other? Not necessarily, right? Their legal relationships arise by operation of law. They don't know each other. If it's a traffic accident, they probably wish they never met, right? So, if you think about forward, backward, and get confused, if you think about, if they would rather that they have never met, go back, right? Go back in time. Okay, so tortious damages aim to put the plaintiff back to the original position, as if the tortious act had never occurred. Okay, so if you think about willingness and contractual terms, you'll be able to distinguish the two. Okay, rescission, we've talked about that. Specific performance is if you have Merriam Young, okay, you are an entertainment company, okay, Yingwang, right? Okay, so you engage Merriam Young, to the pop star singer, to sing on the 31st of December. We passed that, right? So let's say more straightforward. Easter. Next one is Easter, right? So Easter Sunday, you have a concert, and you engage Marion Young, the famous pop star, to sing in what's that Hong Kong Stadium, okay? Okay, the Hong Kong Stadium. And unfortunately, she just told you now that, no, I can't. I have a family engagement I just know about. Or my best friend is getting married. I'm flying out to Canada. That, the night before. So I'll pay you back. I'll pay you money. I'll refund the money. Perhaps I'll pay you a little bit more. Now, as a reputable entertainment company, you don't want to let down the fans. You don't want to lose face. You don't want to go through the admin and of the flop, of the concert having flopped. So you want specific performance. You want to force the famous pop star to actually perform that contract, right? So to compel the defendant to perform the terms of the contract, that's specific performance. Declaration, that can be all sorts of everything. It can be a declaration that yes, as a result of the constructive trust, the property in number 3, the Peak Road, belongs to Doris. Okay? That's called a declaration. Injunction, you already know. Okay, we've gone through some. Okay, so apart from stopping someone from can be for stopping someone from harassment, can be stopping someone from dissipating assets, which is a Morava injunction we talked about last time. So all sorts of everything. Consider time limitation periods. For most contract and tort claims, 6 years in general. If it's a contract under deed, that's 12 years. Recovery of land, which gives rise to what you sometimes hear as adverse possession, those are now 12 years. Okay, any related proceedings. Okay, this is important. Current or in the past, whether in Hong Kong or overseas. If you have parallel proceedings, what we mean is that, yes, it's a PI claim from the accident on 31st December 2020. Is that your client or Peter is now coming to you for help? Unbeknown to you, actually, he has previously started another proceedings on exactly the same matter. Now, if you start another one for him, that's called parallel proceedings. Whether it's in the same court level, whether it's, well, most likely it's going to occur in Hong Kong, but let's say it's on another matter and it's in overseas, that's the same thing. Okay, as long as you're suing or claiming on this based on the same facts and same matter, that would be parallel proceedings. Worse still, if the claim has been tried before and decided, the claim had actually been brought and tried before the court in a previous civil case. And now Peter is just trying to say, yes, I didn't like the decision then. I'm going to have what we call a second bite at the cherry. Okay? So that would offend the doctrine of re judicata. Okay? Re judicata. That means the matter, the same matter has been decided by a court of with jurisdiction in a previous proceedings. You cannot invoke another proceedings based on the same matter. Okay, re judicata. Basically, if you engage in either parallel proceedings or re judicata, your case is most likely to be thrown out. Okay, dismissed, struck out. Okay, we call struck out the pleadings and dismiss the action. Court venue. depending, I think, from your legal system, you know that it depends on your claim, okay, the type of litigation and the amount, okay, and the amount sought. Okay, cost considerations. Advice as the employee or associate or partner in the firm, you would advise client your legal firm's costs and rates. Now, unless you are very, very confident, most of the time you will just tell the client what's the hourly rate and what are the disbursement charges. Okay? It would be extremely difficult to tell them how much the whole action is going to cost, because different things happen. Okay, there will always be changes of plans and things like that. Discuss with your client what is the arrangement for payment of legal fees. Is it going to be privately funded, as in Tommy Construction? Okay, they have money, they're going to pay for the legal fees out of their own pocket. Let's say Peter is not so wealthy. Peter, our traffic accident victim. Not so wealthy, so perhaps you would advise him to apply for legal aid. On the other side, if you're acting for Dimitri, the negligent driver, you would confirm that he should have third party, right? He should have third party insurance, right? So think about all that. Advise fully on cost liability on both winning and losing. Because losing party would most likely have to pay the cost of the winning party, right? So when your client is coming up to you to say, yes, I want to make a claim, yes, I think, well, it's not going to be very costly, isn't it? Blah, 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 advising the risk. And if you lose, you may also have to pay the other side's cost. Any application for security for cost. I'm not going to go through it here at length because we have a session on it, okay, a small session on it. Basically, security for cost is, this time if you are the plaintiff, let's say it's Tommy Construction. Okay, Tommy Construction is a company. Let's say it's actually not based in Hong Kong. The Tommy Construction is based in Canada, okay, Canada, and it has no real asset in Hong Kong. So let's say Mary is based in Hong Kong. So Mary can say, hang on, I think I've got a strong case of defense. I've got very strong reasons to defend Tommy Construction's claim. Now, Tommy Construction, you have no asset locally. You are suing me. You're putting me into great inconvenience and expense to defend this claim of yours. I'm worried. I'm speaking on behalf of Mary now. I'm worried that if you lose and I win, meaning your claim will be dismissed, you have no money to pay for my legal costs because you have no real assets in Hong Kong. So that's the basis for security for cost. Okay? It's normally reserved against plaintiff who resides overseas and has no real assets in Hong Kong. Contingency fees is illegal in Hong Kong. Okay? You cannot charge fees based on the result of the case. That would be illegal in Hong Kong. And remember from your legal study, the only not so official contingency sort of concept is in supplemental legal aid. Remember that? Yes, it charges you something a little bit more if your case wins. Remember? Not really. Okay. Okay, but it's not a straight out charging, right? It's not a straight out fees, and it's government. That's why it's allowed. But for any firm or any council, contingency fees are not allowed. Potential problems in enforcement of a judgment. A lot of times doesn't actually think about it in the beginning. Okay, what if the defendant you're suing has no money anyway? Okay, you would well advise your client to make sure if what you're after is money, damages, then you should advise your client to do financial and background checks. There are a lot of database that you can do that in Hong Kong, okay, to check whether a particular, whether natural person or company, it's like the natural person has any property, etc. The purpose of that is mainly to check whether they are worth suing. Because you can go through your 3 years, 5 years civil litigation process, you get the judgment you want, the full amount you want, the quantum, and found that there's no money left to pay you anyway. And they would just stand there, the defendant would just stand there and say, well, you sued me, you've got your judgment, but I have no money. You can force me into bankruptcy, but I still have no money. Then what's the point? Right? Possibility that the defendant may dissipate assets to avoid paying damages. If you have that concern, then you should apply for a Mireva injunction. Okay, and it's insurance, so that's pretty self-explanatory. If the defendant has insurance, whether as a traffic accident they may have third-party insurance, or even if it's a product liability, some industries it's very typical to have product liability insurance as well. Okay, this tends to be quite important nowadays. Not just because of the typical contractual claim, tortious claim. Now, as you can see from the TV government advertisements, there's been a very rapid rise in fraud cases, scam, like email scam cases, telephone scam cases. I don't know whether you see a lot of advertisements on the TV, right? And sometimes to catch and trace the money is dissipated very quickly. Okay, it's very much on the rise, and it's bread and butter to some firms now of those email scam cases. Okay, so what we have is, let's say the victim or plaintiff under the email scam, so by mistake transferred some money because they thought it was an investment or they were being investigated, etc. So under the fraud and the scam, they transferred some money to the first defendant. Guess what the first defendant is going to do? Send it all away, right? So the quicker, so D2, D3, D4, D5. Nowadays it's actually very hard to catch, but this is typically what happened in those email scam cases. So sometimes we see a typical case of scam with, the most I've seen is about 40 odd defendants. Okay, so they move very quickly. Fortunately, now we have some other police scheme that can sometimes put a hold here as well, but depending how quick you act. If not, if the police haven't put in a freeze on the account as well, then you have to apply for a Mireva injunction. And you have to be very quick. Because all I do is some buttons on the computer, right, for you to send them, to further dissipate the money. Okay, but that tends to be very important now. In the old times, what we concern with is traditional company disputes, matrimonial disputes, contractual disputes. Okay, when we worry that assets will be dissipated away. But nowadays, the email scam and the telephone scams, they are by far very, very common for the need for injunction. Any related criminal proceedings or convictions? Well, if Peter is trying to sue Dimitri for that traffic accident, what if Dimitri, for that accident that occurred on 31st December 2020, what if Dimitri has already been charged and convicted of dangerous driving? Do you think it will help your case? Why do you think so? Remember, now you have a civil case, right? You're trying to start a civil litigation. What's your standard of proof? Civil standard of proof? Balance. Okay, thank you. balance of probabilities, right? What is the criminal standard of proof? So which one is higher? Which one is higher? Criminal, right? So if you have if the military already has a criminal conviction, that's a higher standard of proof. If it's been proven, so it's taken as a fact, because it's got to be certain, right? So that would very, very much support your allegation of negligence or recklessness, correct? Because civil standard is lower, and if you've not got criminal standard proven, based on the conviction, you would want to use that to support your claim. Okay, original documents. You would advise your client to keep all relevant original documents. We're going to look at the stage of discovery later. Okay, probably another 3-4 lectures off. Okay, basically again, discovery is the disclosure of documents, and you have to, apart from giving photocopies of relevant documents to the other parties, you have to let the opposite party to actually come and look at the originals at a specified time. Any specific procedures or requirements for the case? Okay, so sometimes there are, for example, specific rules for probate cases, how to conduct them, or applications for MIP. So that's just a general comment. Whether to instruct counsel is a question of the case complexity. In a very, very simple matrimonial case or PI case, you may not need counsel, right? It's pretty standard bread and butter case kind of cases. If you need to instruct counsel, any preference based on experience, reputation, etc. Remember, in district court and land tribunals, solicitors already have right of audience, so you have a choice, right? Even if you write down to main trial, you have a choice whether to engage counsel. And that small claims and labor tribunal, no legal representation allowed. We talked about ADR last time. I'm not going to do much there. Okay, letter before action, also called a demand letter. Also called a demand letter. It tells the other side, who is it by? From who to who? From plaintiff to the potential defendant, right? What we call intending plaintiff to intending defendant, because they haven't started the action yet. Okay? So the intending plaintiff would send a letter to the defendant or intending defendant, telling them, yes, Mary, Tommy Construction now intends to, lay out the background. Miss Mary, you have ordered on such and such a date, you have entered a contract with us, and we delivered, what did I say, 200 iPhones to you. You failed to pay us by the due date on blah, 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 and now, unless you pay us the price of the goods by within 7 days of this letter, we have standing, let's say I'm acting on behalf, I'm the firm. Okay, we have standing instructions on behalf of our client to sue you without further notice. That's practically what a demand letter is, right? So it invites a proposal for settling a case, like I'm offering you terms, so you can pay me, otherwise I will commence it. Okay? So once, if no settlement, plaintiff will commence legal proceedings without further notice. Failure to issue a pre-action letter can have dire consequences, particularly in some cases, but now it's standard practice. It goes without saying that all intending plaintiffs would actually send a pre-action letter, especially if they are represented. It would be quite negligent for them not to send a pre-action letter. Certain types of litigation, such as personal injuries cases, have specific requirements as to the content. That is a very, very detailed practice direction. It goes through lanes and lanes. There is a section within that, not the whole PD practice direction, not the whole practice direction 18.1 is about letter before action, but a large chunk of it is. Okay? So it has requirements such as you have to specify the date minimum requirement on information, date of accident, date of and bare minimum of what medical evidence, reports, etc. Okay, that you have to give copies to the defendant. Please be careful. Traditionally, when people do assignments or exam, answer exam. Sometimes one of the questions may be, I'll give you a factual scenario, right? The exam question may give you a factual scenario and ask you to state what reaction considerations you will have or you have to consider for your client, right? Fairly typical question for this topic. Please only state the applicable ones. For example, yes, you would advise costs, considerations, parties, causes of action, etc. And typically they mention, yes, you also have to send a letter before action. And you have to observe 18.1. Hang on. The factual question is about a contractual claim. Okay? It's nothing to do with personal injuries. So be careful. Don't just regurgitate everything. Make sure it is applicable. Okay? If we have for some reason, this year it's very difficult. They put an advanced possession claim here. So you don't give them a limitation period of 6 years. Okay? You have to apply. Right? That's the only difference between a standard answer and a good answer. Okay? I've seen so many times people mention this when I give them a contractual claim scenario. They mention 18.1, practice direction 18.1 is only about personal injuries claims. So stay awake with what you're doing when you apply the factors. Limitation period, again, it would vary depending on the cause of action. Land, contract, tort, personal injuries. Okay, all those limitation periods are in Chapter 347. That's called the Limitation Ordinance. After the expiration of the prescribed limitation period, it has the effect of barring a potential plaintiff from commencing the action. Okay, so originally you have the right to sue, right, based on a cause of action, whether it's contractual claim, traffic accident, or breach of fiduciary duty. But if you count it from the when the cause of action arises, let's say from the date of accident. Okay, you have a certain period within which you should bring about the action, otherwise you lost your chance. Oops. Generally tort 6 years, tort with latent damage. What do you mean by latent damage? Okay, so the event occurred. Okay, there's something. Let's say, okay, chuck away, let's push aside our typical traffic accident. Let's say this time the tort is also about negligence, but let's say it's someone repaired or someone renovated your unit. Okay, the unit where you're residing at. Unbeknown to you, the contractor didn't do the work very well. He was negligent. However, the defect is not obvious. And the result of the negligence perhaps is seepage of water. Okay, because, unbeknown to you, the contractor actually drilled a hole somewhere they shouldn't have. And now water seeps through. But it's only, okay, for example, the crack only developed very slowly. So in the beginning, you didn't know. And let's put it in the sort of that kind of scenario. So latent damage is not something that you know at the outset. Okay, it could only be discovered later. So that's latent. 3 years from date of actual or constructive knowledge. Okay. From the time it actually is reasonably discoverable. Or 6 years from date of accrual of cause of action. So you can count either 3 years from you discovered it, the defect, or 6 years from the date the negligent act occurred. So this is our typical one, right? 6 years. The only difference is the 3 years from date of knowledge. Okay. So because normally it would have been 6 years from the date that he drilled the whole network anyway. Okay, that would be the 6 years from the date of the event, or 3 years from the time you actually found out. Personal injury, 3 years from date of the accident, basically. Personal injury with latent damage, 3 years from date of actual or constructive knowledge. Now, I think you would, do you understand what constructive means? Now, actual knowledge you know, right? You actually know. Constructive knowledge means when you ought to have known. So when it's something that with reasonable investigation or reasonable, it's reasonable for you to have found out by that time. Okay, and you hold, even if you don't have actual knowledge, you may be held to have constructive knowledge. For example, an example, let's say you're doing conveyancing for a client. If there's actually a mortgage on the property you're trying to buy, so the last owner has, or the vendor still has a mortgage on the unit, and you're trying to buy the unit, and that mortgage has been registered with the land registry. So it's public record. And that would be constructive knowledge. Even if you did not go onto the land registry website to search for that record, so you didn't have actual notice, but because it's publicly available record, you will be taken to have constructive notice. Does that make sense? Sort of? Yes? Okay. So something which ought to be discoverable. Okay, you should have, ought to have known. Death under fatal accidents ordinance, 3 years from date of death or the date a beneficiary acquires knowledge of a basis of claim, because the person has actually passed away. So the claim may be, so when you see, I don't know, any one of you still remember the Llama Island ferry incident? Right? When you have fatal, let's say some of those people unfortunately passed away. So whenever you have claims based on FAO, Fatal Accidents Ordinance, of course it would not be by the victim personally, right? It would be by most likely family members on behalf of the victim, right? So it can be a beneficiary or it's just a relative, right? The date a beneficiary acquires knowledge of a basis of claim. And those claims from that incident last for years and years, right? Because there were so many of them. Right? If you remember, that was a very, very, very sad incident. Number 6, contract. Simple contract is one where it's just what you normally recognize. As in our general form of contract. The difference in number 7 is contracts made under seal, or what we may use it as under a deed. Right? When you see deed of assignment, deed of gift, those are actually still contracts, but they're made under seal, or we call it contract by deed. So they have a longer years. They are taken to be a more solemn, a more serious or solemn form of contract. Okay, so their limitation period would be 12 years instead of 6. Be careful when we set the date of accrual of the cause of action. Let's say we have a breach of contract, and okay, again, I'm just lazy. Tommy Construction and Mary. Okay, so again, Tommy Construction sold what's the construction? Bulldozers. Okay, let's not use iPhones. Okay, bulldozers like Kodak. Okay, bulldozers to Mary. This time 1,000 bulldozers to Mary. Mary didn't pay. Now the contract date was 31st of December 2020, so last year's New Year's Eve. Due date was 1 month later. So when is the date of accrual if Mary didn't pay? Let's say it's number 6, simple contract. A typical normal contract. So 6 years from the date of accrual of the cause of action. When does the cause of action accrue? Which is the start? Which is the material date? Anyone? Again, the contract was entered into on 31st of December 2020. Payment was due 1 month later. When did the cause of action accrue? Okay, what is your basis of your claim? What is the cause of action? Breach of contract. So when does the cause of action, not the contract itself, when did the cause of action of breach of contract accrue? January 31st, right? Don't mistake it with the contract itself. Okay, so it's when there is the breach of contract, when Mary failed to pay. Recovery of land, 12 years limitation period from commencement of adverse possession generally. I won't go into too much depth because that's a little bit more complex, but basically that's the something, right? Sometimes you see that on the newspaper. So if the squatter, something there, held onto the land for 12 years and have absolute control, fence around it, all around it, let nobody else except himself use the land, that's adverse possession, generally. Okay? Infants and those with disabilities, extended limitation periods apply under some circumstances. Time period runs from when the person ceases to have the disability. And this is interesting because, well, we know if it's mental capacity, if someone is mentally incapacitated, then it'd be difficult to sue them. Well, what if it's infants? Well, infants here doesn't necessarily mean baby in your arms. It just means not of majority age. Okay, 都未夠18歲. Right? So infants in that sense. So interestingly enough, some claims, if you want to claim against an infant or minor, you have to wait till they attain age. If I put number 8 and number 9 together, I can give you a very, very peculiar example. Now, who has heard of 祖堂地? Anyone? No, it's like ancestral 祖堂，即係啲廟宇啊，祖堂 okay? So in some ancestral clan owned land, which we call 祖或者堂，有陣時你見咩鄧咩祖嗰啲 that's what we're talking about, right? So with land held by those ancestral or religious clan, it's a collective. And if you try to have adverse possession against them, you have to wait. And it's almost impossible because you have to wait until every one of them is of majority age. And that's the general concept why it is so difficult to have AP against them. Okay, I just thought that I'd share that with you. That's quite interesting. That's why adverse possession against 祖堂 is almost impossible. Okay, because they keep on having youngsters, right? Okay, I think it has to be male. I think, yeah. So as long as they keep on having male babies and growing up, so you have to wait till the very youngest one is 80. So pretty difficult, right? If you have a whole clan. Anyhow, I just thought that's quite peculiar. Number 10, if there's any mistake, fraud, or concealment, you should remember that from your contract law. Right? If it's active and intentional concealment, time doesn't begin to run until actual or constructive knowledge of the mistake, fraud, or concealment. If there is any specific issue on limitation, it has to be specifically pleaded in the pleading. Okay, we'll look at pleadings acting on our next gathering together. Okay, without delay. So it has to be something specifically pleaded. The court has the discretion to extend the time limit. It's not an automatic entitlement. Okay, you have to apply for leave. Factors considered in an application to extend or override time limit depends on the following factors: length of delay, duration of any disability of the plaintiff, the defendant's conduct, how strong the evidence is, whether the plaintiff had taken steps to obtain legal advice, and the extent to which the plaintiff had acted reasonably. Now, the court doesn't extend time easily in terms of, here we're not talking about whether when the action has commenced, whether you need another 2 weeks to file documents. Here we're talking about you are too late to commence the whole action. And if you're too late to commence the whole action, if the court lets you extend time or disregard the time limitation period, it can be unfair to the defendant, right? Because the defendant was thinking, okay, I'm safe now. And suddenly, if the court extends or for some reason, waive the limitation period, it would be very prejudicial and detrimental to the defendant, right? The defendant thought he was safe, right? Sometimes you may have, let's say, remember personal injuries limitation period is 3 years? Just now we saw. So sometimes some very exceptional circumstances may be because the plaintiff had been really in a very bad medical state, not stabilized yet. It's very hard for him to bring a claim or get legal advice. And perhaps he's only been late for a very short period. The court may sometimes be lenient, but it's not an automatic entitlement, definitely. Okay, we have a reflection activity. Okay, passing the ball to you. What's the main purpose of pre-action considerations? I think it's a rerun of what we went through, but just throw out some ideas. I basically put all the reflection questions and activities here so that you don't really have to go backward and forward. So what's the main purpose of pre-action considerations, you think? Yes? Any suggestion? It's okay, there's no right or wrong answer. It's just very general response anyway.
Save the cost.
Save the cost. Have some, perhaps in terms of cost, maybe have some estimates. Right? Anything else?
Determine multiple courses of action.
Sorry?
Determine multiple courses of action.
Yes, identify and see if there are multiple courses of action. Make sure you've covered all possible avenues. Right? Yes, all courses of action, plaintiffs, defendants. Yes. Clarify the instructions, yes. Make sure you have clear instructions and make sure the client and you understand each other very well. Also a little bit of client expectation management as well. Okay, so all those what we've discussed today so far. Okay, but if I have to ask you for one major aim, I guess when we have pre-action considerations, I would say two major aims. Yes, you have to clarify all the details, courses of action, plaintiffs, parties, etc. But what do you have to think about even higher up? Whether to take and pursue the case, right? What if your evidence is weak, your claim is weak, you have little evidence, went up in fire, okay? And not many witnesses to support your client's case. And also, the other party has no money. Now, even though your firm wants business, it may be it may not be ethical for you to encourage the claim to be pursued, right? If really the case is that bad, right? Your courses of action is quite slim. You don't have much oral or documentary evidence. The other side, the defendant side, also, they have no money to pay even if you win. So you would advise your client and analyze with them whether to go ahead or not. So whether to go ahead with the claim, and if you decide to go, yes, I think we have reasonable chance and we've got this and that, then yes, how? Right? So you can broadly divide it into two questions, whether to go ahead and how. Right? So question 2, in a personal injury, there's no right and wrong answer. This is very much common sense. So it's not like black letter law, but this is just food for thought. In a PI case, what pre-action considerations would you address? So what are some differences that you've looked at, apart from your typical parties, courses of action? What are some distinct features of PI cases that you've observed? Liability and quantum, so you may have a split trial. Yes, probably what else do you have to notice? Personal injuries, perhaps there would be, the defendant would have insurance, right? Whether, of course not in every occasion, but let's say it is we said traffic accident, the defendant may be covered by third-party insurance. If it's a construction site, they're most likely also going to have insurance as well, right? Even if footing, unfortunately, I went past a building, a wing-lock building, okay? Wing-lock building, as a pedestrian on the pavement, a fallen slate from the building hit me on the head, then I still have insurance, right? So personal injuries, sometimes they will have insurance, and also the last, almost towards the last bit, we said there's a practice direction 18.1, okay, in terms of requirements on pre-action letter. Number 3, in a breach of contract case, what pre-action considerations would you address? So because the course of action is based on breach of contract, you would probably have more documents, right? You may have a contract, you may have more records because the parties are engaged in contract. You probably be careful about detailing the terms of your contract. Those kind of things. It's a very general question. Can you think of any other pre-action considerations? I think we can ignore the last one, right? Letter before action, we just saw it. Right? It's just to give the other side a last warning letter almost. How about, can you think of any other pre-action considerations apart from the ones we've covered? No? Not really? Okay, so I can't either. Okay, so you're not, well, I think we've covered most of it. Now, another tip I can give you is when you actually answer a question like this, like you're given a scenario, right? In an exam scenario, in an exam paper, you're given a scenario, ask about, organize. We've probably gone through, or your course manual on this chapter would have plenty of bullet points, right? Plenty considerations. To help you to remember, I normally advise the students to put it into large chunks, as in headings and subheadings in your own way to help you remember them. For example, you may group all the cost considerations together, but and then further into subheadings. Right? For your memory only, okay? You don't use bullet points when you write answers, you know that, right? But to categorize them better to help you remember. Okay, my bullet points are sort of trying to organize in that way already to help you. Okay, so should we have a break? Okay. I see some of you quite feel you at all. Okay, so let's have a 15-minute break. Yes, cool.
I just sit here, honestly. That's definitely just sit here. Yeah, I don't know. Show me for a little bit. Yeah, I think you should be for dinner. It's even worse because you're so tired from your date and then you're just kind of there trying to focus. I thought it was just me. I was like, maybe you have like a short attention span I didn't know about. But then when Greenwood came over, I mean, like, it wasn't that bad. I thought this music. I thought Edward was like pretty bad at some point because sometimes I get A's in his classes and just like find myself just kind of procrastinating. I'm like, okay, and then like that model came in and it was like, oh my god.
I think Edward's main problem was he never really timed his lectures very
like zoom past like 20 slides in like in like 5 minutes, and we're all just sitting here like.
It's like, I think for me it was more of, I feel like there's no structure as well. Like, it goes out of topic, and I'm like, I'm out. What has this related to it for me, in my opinion?
I think it's, and another thing is just support here is I don't, okay, so like I actually, because of the whole assignment thing, I was like, okay, how do you get better, right? That's why I asked if there's any like, I don't know, it's not the same course as like uni or whatever, high school, something like that, but like if you have papers done by other students, you can read those things, maybe you can understand better how they did it.
The structure basically, right?
And how to use legal, how to properly use legal language. I'll give you an example, I can make you learn better.
Yeah.
Just while I was like, hey, does anyone have that? No. Okay, is there any mentors or someone I can talk to? No, just talk to your teachers in class. Okay, but what if I have a question outside of class? Oh, well, that's too bad. Too bad, we don't support that. And I had to bug with people quite a bit, phone calls, and I'm like, oh, you need to send this to your teacher, you can send it to this email, and then they'll forward it to them, and they might reply to you. And it's like, really, that is our support? I mean, we're not exactly paying like a small amount of money for jobs to do support, and they're like, this is what they said to me. This course is actually really easy.
Excuse me, what?
Yeah, they're like, this course is actually really easy, which is why we don't have any mentors or basically they're saying, oh, it's because you're dumb, that's why I don't have any support for you. I'm just like, are you
It's rude.
It is very rude. Because they're like, oh, you see, the course must be really easy.
So law in general isn't easy.
What if I'm dumb, okay?
What if I have to do extras? I have like sweatshirts.
What if I'm stupid, okay? Support me.
You start breaking down and like at home trying to work your assignment.
What if I'm
someone sent me an answer for this?
I'm just stupid, come on.
I think it's I have my friends studying the financial. My friends studying the financial part of graduate finance, and he's just reached the law part. And he came to me one day. He's like, I don't know how you do it. I can't focus reading this stuff. And I'm like, I don't know too. You just have to pass through it. This is my course, so
You just have to do it and just try your best on the phone. Like, it's not, I don't know what, but I've read some sentences which just like, and you reread the sentence 5 times and you still don't really understand it, and then had that experience before when you do the cases and stuff.
yeah, it's some judgments. I think the first one was there was a judgment we read everything, and one of them was quite difficult because even though you go over, you just realize I still don't know how to put it in like layman terms. Like I think that's how I try to do it. Like how I try to learn is more from it. I read against like literature, and then you try to like put it in words so that you understand. There's somewhere I can't. I just
It takes a lot of brain energy to like just try and like I thought I knew English and that I don't. You know? Yes, I didn't know English. But yeah, like I remember reading this one sentence pages, and my mom who also she studied law, so I was like, can you come over here and read this? And she was just like, oh, this sentence is just saying that I'm asking. I'm like, wow, how do people do that? I'm like, I don't know. She's like, don't worry. Just the more you do it, the better you get at it, and the more you understand. It takes a bit. I'm like, I don't know, man. And I'm just like, why? I don't understand. Why do you need 15 words to say that the judge gave him? So simple. Just say that.
30 pages. Did what they call it? Is your mom working in like as a lawyer?
She apparently did, but now not. She's just like,
I think it's more of like it's like you can just send on one page. Do you really have to? But I guess it's like sort of
it's old English.
yeah. And remembering all of these Latin terms, I'm just like I don't how. How do you remember these terms?
Was the one we missed one? Ray, Judy.
Judicia, I think.
Yeah, something like that.
I know, like, I know, like, the one it's easy for me to remember is like mens rea. I think it's a bit more related to criminal law. But I think it's just I don't even know how know what it means, but I just know it. I know the word. I don't know the meaning.
I feel like Latin, personally, I've always been interested in Latin, which is why I don't mind learning the words. It's just remember, there's so many cases to remember, like, especially with, like, I appreciate, like, whether it's this must know, this must know, this.
Oh my god, yeah.
But there's so many must know cases, just for this module. I'm just like, oh Lord, we want to know what other modules, and how you gonna know? I'm just like, very good.
Well, that's crazy like saying is like, you notice, don't you? You like say,
You notice, don't you? You can go to your like,
do I
notice?
should I have? I was like, and then he's like,
He's just like, you better know the Gibson principle, you better know. I'm just like,
he was asking about the court law, and then I'm just like, oh my god, he was gonna be so disappointed. It's like seeing him like running in, what is acceptance? What is like
negligence. What are the elements of negligence? You better know this.
and he's like, I don't work under pressure. I think I'm negligent of my studying. That's all I know.
I'm negligent of my studying, please.
Give me a chance. You know this, don't you? Cannot take me out of my head. Like I'm just like, oh.
It's not innocent negligence. Not innocent negligence.
It's so funny because I'm like, I feel like we all have blank faces, but we're just so sadness. So like, so you guys, like everyone's just like tripping in the room.
Yeah.
I'm like, not sure if shy or. I'm like, what was that again? I know it's someone we're living somewhere, and I know they're level for something, but it's cool.
Water damage. Case about that.
And so many things to remember, honestly. Like, how are you taking all of the exams? I checked the whole
And they were like, you can only do it if you pass. So I'm just like,
oh, right, yeah, and you could only, I think it was only after their certificate, and I think it's because like of you receiving your you can get the reimbursement back. But if you fail it, like as like what they say here, too bad for you. You know, it's supposed to be easy.
the main reason why get the amount of
At some point, I was studying, and I'm just like, I don't know why I don't remember these things. Like, is my brain not working enough? I thought I could handle this, but I don't. So I'm just like, yeah, there's days where you're discouraged and you're kind of scared. I'm like, but then there's days where I'm just like, yeah, it's time for you to get it down. But I think I understand what it's about reading the book. It's not how you memorize. It's not memorization. It's understanding, I guess.
you need to know what you're doing. The thing is, you can't remember. I mean, yes, he comes both and everything. Like, what's his name? Ezra said that there were some things out there who stretched for everything even if they didn't understand it. Yeah, he said there were like some of his top law students who are just reading and remember everything. They don't actually understand it.
But
And
it's
it's
like memory.
And it's like how? But like the thing is, I think it's easier to memorize and understand. Like when you understand it, because if you understand it, it's easier to commit to memory. But if you don't understand it, you're just memorizing supposedly meaningless information. So it's easier to just
Yeah, like what I'm thinking was I have like a lot of recent information, like lyrics of songs that I've heard like the line, or random stuff on the internet, like this random meme, the story behind it. I'm like, how do I remember those things? And I don't remember like what I studied before. Maybe it's like the interest on it, like there's something that was really funny.
And you find them interesting so much more. I totally understand it so much.
Do you find time like you probably like work? Are you working?
Oh no, I'm still.
Are you taking two courses?
Well, no, I mean, this course and then also I'm taking
Oh my god. How do you split?
I mean, okay, I'm alright at English. And the course I'm taking is actually, it's not too difficult. It's not, like, the workload is not too hard. It's mainly just the same thing every day. You just write essays. And it is very tedious, I'm very annoying. It's something I've, developed the habit of speed running. It's just like, oh, my essay's due in 6 hours. Go.
Do you have a literature in that area? In your major? Do you have
Yeah. Specifically comparative literature. So, you don't have it. No worries. It's like it's just fancy talk for like you literally just take a piece of literature and you compare it to another piece of literature and you're like, beans. That's basically of course there's where we look at like world literature, we look at like influence study, parallel study, like just stuff about like how literature is developed, the history behind it, various authors, various movements, blah blah blah. That's kind of it. And then you write an essay. I mean, I've written so many essays, so it's just
You're like a essay master now. It's like
now I'm a master of procrastinating until the last minute and finishing my 2,000-word essay in 6 hours.
I asked working smart, not smart.
Why would I spend time actually being a good student and writing my essay when I can just
Do it last minute.
do it last minute and stress out completely for the next 6 hours and then I'm finished?
That was me on my that was me for Hong Kong physics law. Like I had 2 weeks. I just did not revise. I had no time to revise. I was so busy. So I was just like, oh my god. So every day I was studying and just kind of like cramming everything to my head. And so at some point I decided to like skip like a chapter and just kind of like skim through it. Skim through it, skim, and like the whole weekend.
Look for the specific word.
Like, where is it?
Personality test. Where is it?
And I'm like, do I have to like this library? Do I not have it? Like, what is this? And I did not know. Like, am I in too much? So yeah, so I'm just like, no, I have faith in what I do. And if this come back great, then I'll do better next time. So I just
Just do your exam round. Pray.
maybe like have a mini breakdown, but you know, you have to time the breakdowns too, so you can go back to study. That's fine. I just promised myself like very, very like good food when I'm done with the exams. Like, I'm gonna go to like somewhere nice and just eat steak and something.
Just chill.
It's like reward yourself for the hard work you've done. Yeah, that's what I aim to eat good food.
It's the motivation, right? It's really great motivation.
Somebody don't often work because you know you work hard for it. As in like you've tried so hard to get through this course.
Another thing is like if you do your best, you can have the feeling of no regrets. Because it's like I tried everything and I didn't do well. Well, what can you do? Maybe the people in the call center were right, and I'm stupid. I still can't believe that phone call. Oh, this is a really easy course. I don't even have anyone to support. I'm like,
You should ask them, have they tried it? Have you studied them? You know what it is. But it's cool. I think it's pretty, it's great. I actually enjoy it. It's a little bit.
I mean, I will say like it's definitely very different from because I remember you talked about it like before, saying, "Oh, you're using English, right?"
Yeah.
Yeah, it's very different. I would say the legal writing is very different from like literature writing.
See ya.
Left is full, man. Oh. So, don't tell me you left is full. Maybe if you really love then this is the world.
Revenge or there in action, they don't recall. Okay, let's go. Okay, now, good news and bad news. Now, remember topic 1, 2, 3? So far, we've gone through a lot of things that have common sense. And now we are starting to be a little bit more black letter. Okay, so pay attention now. 之前講啲好多都係啲好 common sense 邏輯嘅嘢，係咪？ Right? So from now on, we start going to talk about how proceedings can be kick-started. Okay? So how do we commence? Civil litigation commenced. Is it on? Is it on? Yep. Civil litigation is commenced by an application to the registry at either the CFI, Court of First Instance, or the District Court. In actual fact, I would normally call it the High Court Registry, because there is no CFI registry. It's actually called a High Court Registry or the District Court Registry. So why do I say making an application by way of an originating process? Now, whenever we talk about originating process, it's a document once you have it issued, it signals the commencement of a civil proceedings. There are 4 types. 4 types of originating processes. Don't confuse. Yep. Don't confuse the originating summons with originating processes. Okay, originating processes include all 4 types. Writ of summons is what we are going to concentrate on as writ actions in this course, because it tends to be the most complex. Okay, we're teaching you the most complex form out of the 4, because writ of summons is also the most common type of civil actions. Okay, so writ of summons, originating summons, originating motion, and petition. As I just said, writ actions are the most common form of civil actions. Originating summons and originating motion and petition, they only used as prescribed by the rules of District Court or High Court. So you only use originating summons for specific actions, such as there are some landlord and tenancy recovery, like recovery of possession at the Lands Tribunal. You have to use originating summons if you're at the Lands Tribunal. Now, originating motion is actually quite rare now. It's probably the rarest form now. Petition, you've probably heard of winding up petitions, bankruptcy petitions. Okay, that are company related. Okay, that's for petitions. But funny enough, all matrimonial proceedings are also by way of petitions. It's just another category of actions that use the form of petitions. Writ of summons. Now you can almost forget this definition. It's a very theoretical textbook definition. It doesn't mean much nowadays. All you have to understand is writ of summons is one type of originating process, which is typical for cases, civil cases that involve a lot of factual disputes, and hence is the most common form of actions, civil actions. Okay? In most instances, when we have civil actions, we have factual disputes as well as legal disputes. Sometimes we have legal disputes because the area of law is not settled. Otherwise, we are arguing about the applicability, the application of the law to our facts. But when you are disputing about what happened, based on documents, based on oral evidence, that's factual disputes, right? If Tommy Construction and Mary is disputing about that contractual claim, which day the contract was entered into, what were the terms, whether Mary had paid in part or in full, those are all factual issues. Some of the factual issues perhaps is very hard to be disputed because it's all right on the document. What if they have copies of documents on different dates, dated differently? There were actually 2 contracts for some reason. Okay? Perhaps one is real, one is forged, or perhaps both have been signed and the contract have been varied. Right? Those are all factual issues. Writ of summons in general is governed by Order 6, Rules of High Court. Get used to RHC, that stands for Rules of High Court. Now, between Rules of High Court and Rules of District Court, the numbers are normally the same. And I mean normally, sometimes they are different. Okay, Rules of High Court and Rules of District Court. So to avoid confusion and to avoid having you to remember 2 sets of numbers, we are teaching this course based on RHC only, so you don't have to remember 2 sets in case they are different. And you would know by now, if you look at any part of your menu, that means order and order, let's say 6 rule 1. So we would normally say RHC order 6 rule 1, like that. Okay, that's how we normally write it in short form. Pretty simple. The standard form is on your, it's in, I think you have a copy in your course manual as well. The standard form is in Form 1, Appendix A, in the Rules of High Court. Remember the e-legislation website I showed you last time? Rules of High Court, anyone remember the number? It's Chapter 4, capital A. So if you don't want to, if you want to just have a, so it's Chapter 4A, okay? Rules of High Court. So you can just check that out anytime. A writ of summons. Now, someone just asked me a few more questions about limitation period. So we said that, okay, limitation period, if it's a contractual claim, you have to commence the action. If it's a simple contract, you have to commence the action within 6 years, right? It was 6 years. January 31st, right? 2021. So what do you mean I have to commence the action before then? Remember the important word is commencing. So starting the action before the limitation period runs out. So you have to commence the action before 31st of January, 6 years, so 2027, right? 6 years. And by issuing that writ, you've put a stop on the running of the limitation period. Okay? So just before, as long as you do it before the limitation period ends, you issue the writ. That stops the limitation period from running, so you can then progress on the rest of the case. Now there's a difference between issuance and serving. Okay, we said, okay, issued within limitation period, stop limitation period from running. The writ itself, okay, I'm going to keep on calling it the writ, although the full name is writ of summons. The writ is valid for 12 months. From when? From you get it issued. From the date of issuance, it has a 12-month validity period. It must be served on the defendant before expiry. So within that 12 months, you have 12 months after you have the stamp of the High Court Registry issued. Okay, serve it on the defendant within 12 months. Now, there is a difference when you are studying civil procedure terminology matters. Distinguish between filing and serving. When you file a document, you file with the court. When you serve a document, you are serving it on the other parties. Okay? We always call it service or serve on. Okay, whether you have 3 defendants, 1 defendant, whatever, all other parties. Serve is serving on parties. And if it's filing with court. So even without saying filing, file and serve, it means both filing with court and service on the other parties. Common types of actions started by writ. All sorts of everything. Tort, contract, breach of fiduciary duties, trusts, equity and trust cases, contentious probate actions. Remember, contentious means there are objections from other sides or other parties. Okay? Claims based on allegation of fraud, adverse possessions. Admiralty actions have to do with ships, okay? Ships and marine law. Intellectual property cases. Originating summons is governed by Order 7, Rules of High Court Order 7. I don't think you really have to remember the form numbers. Okay, I think. Okay. You don't have to remember exactly the form numbers. When you have to remember, those that you have to remember, I will specifically mention it. Okay, the standard form, Form 8, general form, and Form 10, expedited form. By the word it suggests expedited form, it means you want a quicker hearing. Mainly disputes in construction of points of law or documents. But it doesn't just end there. This is a typical, some typical examples, but as I said, some courts and tribunals prescribe that you have to use originating summons. An example I gave to you was at the Lands Tribunal, landlord and tenancy dispute. The landlord is trying to recover possession of the leased premises, plus recover rent arrears, like overdue rents. So that would be another example of OS. Also used for judicial review in chambers, registration of foreign documents, construction summonses, trustee, pre-action application for discovery. Now I think this one is on the rise for exactly the scam cases that I told you about. When remember what pre-action means. It means before an action has been started on the for the matter. Remember the example I told you about the dissipation of assets? The scam? Remember? Right? Under email scam, victims sent money to first layer. We call it first layer defendants. And then first layer defendants further send away, dissipate the money away. Well, sometimes, in those cases, I cannot tell who actually posed that scam because they are anonymous, right? I wouldn't know who the fraudster was. And to prove fraud and actually get the person is actually pretty difficult because they hide behind the phone and the IT world, right? Or otherwise impersonated identities. So in order to find out who they are or where the money has gone, I may, even before I start the action, have to ask for discovery from the court. Now sometimes it is directed against the defendants that I'm suspecting to, if I actually know who they may be. Other times, I may be seeking discovery against, reaction against banks. Because they are the one holding the money, right? And by getting information from them, I may know how much money's gone in, out, etc. But the banks, because of privacy issues, because of their fear of legal liability, they're not going to give me any information unless I get a court order. So this is would be an example of the action discovery. Originating motion, mainly used previously for judicial reviews, trademark ordinance applications, and arbitration. It is quite rarely used now, very specific instances. Now, if you say, hang on, Vivian, you're telling me it's rarely used where, well, if I have a specific application, or if I have a particular course of action, I don't know where. Well, if you go back and look at High Court Ordinance, Lands Tribunal Ordinance, they will actually tell you what forms you have to use. For example, when we get to, let's say, the rules of the courts, they tell you very specifically which form is to be used, how, is there a standard form? Just like when we go to interlocutory applications, they're going to tell you, yes, you have to do the application, make it by summons and affirmation. So they will actually tell you in the rules when you actually have a specific course of action or going to a specific tribunal. Petition now mainly for winding up or bankruptcy proceedings and matrimonial proceedings. Also sometimes for building management applications. Now for writ of summons and originating summons. sometimes people use them interchangeably. Okay, so they think they can, it's a rather simple case, they may go for an originating summons. An originating summons would involve simpler process from the commencement of action to the main trial. And because it's a simpler process, it tends to get to the hearing stage earlier. And that's the advantage of it. However, there would be instances where a plaintiff started the action by originating summons, and then it turns out that no, the case is more complex than he anticipated. So he does need to go back to all the complex procedures because he wants to make certain applications that is not allowed in an OS. So he wants to give detailed expert evidence, he wants to give make other applications, and so on. And perhaps he also wants some specific reliefs that is not available under OS. So the court can actually give directions, okay, although a plaintiff can choose to start the proceedings by either writ or originating summons, if there is no rule to prescribe which one is required. The court can give directions as to the manner in which the proceedings shall continue if the court considers that an inappropriate originating process has been used. So the court can give directions if the case has been started by an OS, and the court thinks, no, this is a writ action, all right, because there are too many substantive factual issues and disputes. The court actually can direct and give directions, I think it's something in the line like, this action be changed to a writ action, to change into an action as if it has been commenced by writ, something along that line. So the whole thing then turned into a writ action, even though it was commenced as an OS. Oops. Oh, yep. Originating summons is more suitable where the case is concerned with points of law only, so it's more legal disputes rather than factual disputes. With points of law or construction, meaning interpretation of documents, less substantial disputes of fact. While for writ of summons, it usually involves more elaborate interlocutory procedures and a trial where witnesses give oral evidence. It's suitable where there are substantial disputes of facts. Apart from that, certain types of cases are classified according to specialist court lists to aid the proper and efficient management of these cases by the courts. There are many. If you go to the judiciary website, you will remember that there are prefixes, right? HCPI stands for High Court Personal Injuries, HCAL are High Court Judicial Reviews, and so on. That's actually a relatively long list. Okay. So that would be your judicial review list, commercial, construction, PI, etc. And then, of course, you have lists such as winding up, bankruptcy, and so on. Okay, HCA, whenever you see the HCA, is a general high court action, so not under the specialist list. Okay, I think it's just for you to know. It's not really the Admiralty list, miscellaneous proceedings list, general high court action list. That's the HCA, by the way, that I mentioned. Okay, HCA, companies winding up list. Oh, I put it here anyway, so otherwise you can also look them up in the judiciary website. Okay, you're not meant to memorize this. Okay, this is not as important, just for your additional information. Okay, I think, so which two methods of originating processes did we say is most common? We just went through. writ of summons, yes. And originating summons. Okay? So the other one is originating motion and petition. Those are the other two. Do you think it would have been better if there's only one method of originating process, so everybody can go through the same channel and same procedure? Do you think it's better or worse? Anyone? Better? Worse? What do you think?
Maybe quickly, those within the procedure can adopt a quicker method.
Yes. So if the case is simpler, it's better to have a simpler method, right? So we can get rid of some or handle or be dealt with in a quicker method. So do you agree? Yes? Okay. Provide examples of courses of action that may be commenced by a writ. We went through quite a few of them now. Your general what were some of the examples of cases or courses of action for writ actions? Remember Tommy Construction and Mary? Contractual claim and tort, yes. Company disputes can sometimes also be, barring not talking about bankruptcy and winding up, but other company disputes. Okay, equity and trust, property cases, land cases. OS, what about originating summons? What about OS? Dispute of law, construction of documents, arbitration. When you have disputes of law, now one of another typical applications or case would be vendor, what we call VP summons, vendor purchasing summons, vendor purchaser summons. It's when people have title disputes. As in, okay, let's say, what's your name? Alice and Matt. Okay, so Alice is selling, Alice is a vendor, Matt is the purchaser. So to have the conveyance transaction, Alice has to, as a vendor, has to show good title to the purchaser. So let's say Alice says, yes, here are my documents, these are all the titles and deeds and proof of title that I have, and then hand it to Matt's solicitors. And his solicitors actually say, no, actually there's a missing link here. There's a missing link here. I don't think it's good title. Or, hang on, there's a notice from the breach, there's a notice of breach from the lands department, okay, or the buildings department. There's an encumbrance there, some defect. I think that's a defect in title. I'm going to challenge it. So that's a vendor purchaser summons. Okay? So it's purely on title. So it's a legal point. That's another example of OS. Okay? A very typical one. The more volatile the property market, the more number or the higher number the VP summons. As people sometimes want to get out of their deals, okay, in fluctuating markets. When the market is flatter, it tends to be less, okay, because people will have consequences, right, if they back out. Okay, I think that is my last one. But since we are so early, I will probably start a little bit on the next one. Okay, probably another until probably with you 5:30, right? So probably until 5. Everybody happy? Okay. Any questions so far on the originating processes? Everybody good? Okay. Now we're going to have a quick review of this topic because we want to, this is a very, very important topic. Pleadings. The storytelling. Now so far what we've told you is yes, what you have to think about before starting the action, how to start the action. But remember, the starting of the action is not the service. The starting of action is when you issue the writ or the OS at the court registry. That's the starting point. The action has been commenced from that time onwards. When you actually serve the writ of summons or your pleadings is another matter, so long as you do it within the validity period. If you are late, remember the writ is valid for 12 months. If the 12 months expired, you should, just before the expiry, get an extension. You can get an extension, you just need to apply. Right? But don't wait until it has actually expired. Okay, pleadings is the next stage. Now, remember in my first class I told you, no ambushes, no surprise in civil litigation. Everything is very much out in the open. In the pleadings, there are documents by each party, prepared by each party, stating the version of events. Tommy is saying, okay, or Tommy Construction is saying, yes, on such and such a date. Oh well, they will actually give a background of the company, of the parties. Then they will state what happened on when the contract was entered into, and Tommy Construction did deliver the goods, the bulldozers, to Mary on such a date. Mary accepted and acknowledged. Before that, I will also plead the terms of the contract and how the goods were delivered, on when, etc. And then the fact that Mary didn't pay, so therefore Mary is in breach. That's Tommy Construction's version of events, right? So that is what Tommy Construction is going to say in its pleading. Mary's turn. Okay. Tommy Construction tells his story as the plaintiff in a document we call Statement of Claim. We'll have that later. Okay. Mary's turn now. Everybody's allowed there to tell their story, right? So Mary's turn. Mary, in a document called the defense, is going to say, yes, I agree. Tommy Construction and I entered into contract on such and such a date. I do not dispute the terms, so yes, admit. However, first of all, upon the delivery of the goods, I found that there was, instead of 1,000 bulldozers, there were only 750. Okay? Only 750 bulldozers were delivered. Further, those bulldozers don't work. Okay? They were defective. As a result, Mary couldn't sell it to her customers. And she also sustained a loss. Like Tommy Construction is saying, it sustained a loss, right? And wants to claim against Mary. That's a claim. Mary turns around and says, no, because of that, I couldn't pass it on to my customers. I suffered a loss. Also, perhaps that's claim by her customers against her. So perhaps Mary would even make a counterclaim. Okay, so that's not uncommon. So after that, okay, remember it's like a tennis match, badminton match, tennis match, whatever. So Tommy, statement of claim. Mary, defense. As a plaintiff, he always had a last say. He has a document called, he's going to respond with a document called reply. Okay? Reply and say, in response to Mary's allegations, no, I did deliver 1,000, or perhaps he say, oh, after it was actually 998. And we have inspectors checking the quality. It was all okay. Because that was in response to the issues raised by Mary. So they have rounds of pleadings, normally only up to that. Statement of claim, defense, reply. Normally it stops there. If it's a very, very complex case, we also have subsequent documents called rejoinder and surrejoinder. But those are rare and requires leave of the court. Normally it stops at reply. After the reply, that's the all of the pleading stage. So let's look at the theory and some definitions. The pleading is a formal document in civil proceedings to give notice of claims and to define the disputed issues between litigants. As I've said, parties in civil litigation is not allowed to ambush the other parties by surprise. Each party must tell the alleged events in his own case and plead all material facts. Why do we call it the pleadings and plead? Okay, telling the facts. We don't call tell. We say plead, pleading the facts. That's why it's called pleadings. Okay, and plead all material facts. Only the pleaded issues will be considered at trial. There's been quite a number of Court of Appeal cases and even Court of Final Appeal cases that state that principle. If you did not define an issue and plead a fact or issue in your pleadings, you are not allowed to mention or argue it or rely on it at the main trial. So that's quite important. Even if you have stated that those events in your witness statements, still you would not be allowed to argue those issues if you have not stated in your pleadings. Okay? The issues in dispute are defined by pleadings and not evidence. Excuse me. Very noisy. Plus, there's disclosure duty of disclosure by all the parties. Oops, excuse me. Okay, so in a way, when we have pleadings, when we talk about the principle, no ambush, no surprises, the pleadings and the discovery and subsequent witness statements all work towards that. Everything is disclosed to all parties. Purpose of pleadings is to inform the other side of the nature of the case they have to meet, to prevent surprises, ambushes, etc. Also, because of the issues raised, let's say, in our case, Mary is alleging she only received 750 bulldozers, right? He says 1,000, or it, because it's company, it says 1,000, she says 750. So, how do we prove? So because she raised the issue of 750 rather than 1,000, Tommy may then think, hang on, I had a third party or independent inspection. Let's say, what's an inspection company in Hong Kong? I think that's one called SGS. That's a third party independent inspector. Right? 有啲係公證行公司. Right? So, hang on, before I deliver, I got an inspection company, a third party one, an independent one, to come and check the quality and also to count the numbers loaded into the container. So I have proof. So if Mary did not raise the issue of the number of bulldozers being 750, Tommy Construction wouldn't have considered having to dig up those evidence, right? And what if Mary if all the while it's only been based on the claim based on 1,000 bulldozers and just on the products being defective? Well, Mary would not be allowed to just at the trial and say, oh, we only received 750. So I want to claim the difference anyway. Mary wouldn't be able to do that at trial because you didn't let Tommy Construction have the chance to respond to this allegation and prepare evidence to object or oppose your allegation. Okay, so that's the idea. Okay. And because, why can't you just rely on the evidence rather than why do you have to define it at the pleadings? Because pleadings is an earlier stage, right? You define the issues, then you go on to the evidence. Because you have the framework, then you fill in the gaps, right, to support your case, not the other way around. Yes, to enable the other side to know what evidence they need, to limit and define the issues to be tried. Otherwise, it's like guerrilla warfare at the trial. So if you just bring up different issues as you like, right, the whole thing is going to be a mess. If you define the issues beforehand, much early on, then you can even, remember we said that we even want to determine the chronological order of dealing with the issues. Right? So you can't do that unless all the issues have been defined. Pleadings should be Korean Exchange Bank and other. I think by now you know this means and other, right? ANOR, yes, you all know that, right? And ORS means others. Do you all know that? Yes? No? Okay, you should learn that early on. Okay, so if I have Wong and other, and always read this as and, right? You don't read this as versus or v. Because when you progress onwards, you don't want people to laugh at you for citing in the wrong way, reading it out in the wrong way. Okay, and Dickens and others, and then citation, whatever. Okay, 2008, whatever. Okay, that means an other, and this means others. So what it means is, this is plaintiff side, right? You all know this is plaintiff side, this is defendant side. Assuming it's first instance. Okay, it's the first time the case has been tried. So you have the plaintiff being Peter Wong and one other. Okay, that's another just means one other. When you have on the defendant side, you have Dickens and others. So it can be Dickens and two others or three others, as long as it's more than one other. Okay, so multiples. Okay, so that's all. But bear in mind that when you sometimes you see, why do I see, Vivian told me it's Wong, another, and Dickens. Why do I see Dickens and Wong? Why is it reversed? Perhaps it's because it's gone up on appeal. So the order, when you go on appeal, let's say this is CFI for some reason, CFI, let's say Wong won. Okay, let's say the plaintiff won. They again progress to CA. Now Wong, the plaintiff won. Dickens was aggrieved, unhappy about the decision. So then he brings on an appeal, and he would then be, sorry about my writing, he would then be the appellant. So he goes first here. That's the reason why you sometimes see them reversing. Okay, I'm not going to bother with the others, okay? Respondent in terms of the appeal. And then sometimes if it goes on to CFA, perhaps it will reverse again. Okay, that's the only reason, whether it's Hong Kong cases or UK cases. So if you have, if you're referring to a precedent that is quite complex and it went on multi-levels, you should, even if you don't remember year numbers, at least remember where the judgment is from. Okay, is it the CA trial or is it the CFA trial, etc. Okay, you should bear that in mind. Where did I put mine? Okay, so where were we? I sidetracked again, sorry. Pretty much covered. Now this is the order that I told you about. The only difference, remember what a counterclaim is? If Mary makes a claim back against the plaintiff, that's a counterclaim. Okay? That's the only difference. So, Tommy Construction starts with the statement of claim, claiming against Mary. Mary then prepares a defense, and because Mary wants to claim, there's a related claim against Tommy Construction, then we have defense and counterclaim. Let's assume we have a counterclaim. Okay, so then that's a defense. Defense against what? Against the original claim. And the counterclaim is like a new claim against Tommy Construction. Okay, it's related, so it will be put in the same case together. Again, defense against the claim. Counterclaim is like a new starting point here. I want to stand up and make my claim also, but I'm the defendant, so it's a counterclaim. Next stage, assuming there's a counterclaim, Tommy Construction then have a reply to what? Reply against the defense. This reply is against the defense, just like the defense is in response to the statement of claim. This reply is in response to the defense. This defense to counterclaim, so you cut it off here, okay? Reply is one part, and the second part is defense to counterclaim. It's responding to Mary's counterclaim. It's quite clear, right? Pretty simple. As I said, the next documents would be called a rejoinder and surrejoinder. Now, I've only ever seen a rejoinder. I've never seen a surrejoinder yet. With an asterisk here, I'm noting that this too requires leave of the court. Statement of claim, defense and counterclaim, and reply and defense to counterclaim, pretty standard. Okay? This too, optional, and you require leave anyway. When you respond, Tommy Construction is making allegations against Mary. The whole idea of the defense is to respond to each and every allegation contained here. So it's like defending against the attack. If you like, I do things a little bit differently. So next time, if we have spare time, in the next session, when is our next session? Tuesday? So towards the end of next session, I will show you some real, not really templates, but real samples. Right, there are also some in your, I think there's a statement of claim, and I don't think there's a reply. There's a writ and a statement of claim in your course manual as mock samples, but it is a very, very simple one. Okay? If we have spare time, I don't mind sharing with you because I've redacted, as in cross out the names and identifiable bits. I've redacted quite a few templates in both statement of claim, defense, reply, and I'll show you some of them, just to make it a little bit more interesting rather than just theoretical. Okay, so any questions? I don't really want to go into very, very detailed bits because I think the next stage is quite... Oh, okay. No, I'd rather not, because I can't stop right in the middle. So any questions so far? Yes?
What is the meaning of rejoinder in this?
It's basically if, after the reply, see, it's saying, plaintiff saying, I have something to say. I have some allegations to make. In making the claim, the defense is saying, I have something to say in defense of the claim. Reply responds to the defense, defense to counterclaim, respond to counterclaim. Rejoinder is if there are still issues raised in the reply that the defendant wants to stand up and say. It's just the other side. If you can see, Plaintiff's turn, defendant, plaintiff, defendant, plaintiff. It's just, although what you can do in the, how should I say, you should only do a rejoinder if there are things in the reply that you have not had a chance to say in the defense. Now, when you plead your version of events or tell your story, so to speak, when you tell your story, you're supposed to tell it in one go, in a complete package, right? You shouldn't do it by 好似擠牙膏咁, right? Piecemeal. You should do it in one go, give a complete story. Now, if for some reason, in response to the defense, the plaintiff is saying, well, I have evidence to say that, yes, I had inspection on the quality. That raised a new issue, right? That sort of raised a new issue that, yes, there was inspection done. Yes, do you agree, Tommy? So Mary may want to stand up and say, hang on, nobody came. No, well, actually, let's say you wouldn't know, right? But let's say you actually share premises or just next door. And for some reason you know, or you have an employee there that day, alleged, etc. Hang on, nobody inspected. So that is a new defense, or fencing off the allegation of the goods having been inspected. So if you have something to say because of what he said in the reply, that you hadn't had a chance to deal with in the defense because he only talked about the inspection here. But you want to close your gate and protect yourself and respond to that. So you may have a rejoinder. And if the plaintiff in turn wants to say something else, that's the rejoinder. That's all. It's still tennis match. Okay, but normally it doesn't. It very because the court wants finality as well. Not necessarily the whole case, but at least at the pleading stage, you can't go on forever. That's why after the reply, if you want to say further, you come and ask me for leave. Come and ask the court for leave. If you want to say further, you probably have to explain to me why you haven't said it, why you didn't have a chance to say it in the defense. And I won't allow it unless it's necessary. Unless it's material facts, unless it's necessary to defend your case. Likewise. Okay? That's why court leave is required. Any other questions? I won't go into any particular pleadings until next time. Gets into too much fine detail. Otherwise, you're welcome to call it not a night, but an afternoon. I'll stay there for a while for any questions. Any? Sometimes you guys can ask questions in open as well, if it concerns because what you think you don't understand may not only be you.
I don't know, maybe he has a good reason.
Don't be shy.